The Racketeer Influenced and Corrupt Organizations Act is also known as RICO. And it is a federal law that was enacted in 1970 by Congress to combat crime groups, specifically the Mafia and La Cosa Nostra. The issue here with RICO is that there's specific criteria that has to be met to prove a RICO violation, and it can sometimes be daunting on the prosecutors. But either way, the government enacted this as a way to put an end to illicit organized crime organizations and their criminal activity. RICO has been deemed the most important single piece of legislation ever enacted against organized crime. So this began as a target against mafia groups, but has expanded and covers any corrupt organizations, and it comes along with a steep punishment. Even though on their own, the violations may not have been considered a violation of any federal statutes, under RICO they are, depending on how they're proven. So the reason this is so important is because it changed the way that prosecutors can convict organized criminals, because it also allowed them a little more freedom in the way that they collect evidence, because it allows them to collect it against the entire enterprise rather than just against a single individual. It also allows the prosecutors to deliver a big picture in the courtroom instead of in just fragments. Also under RICO, they can charge each member of the criminal enterprise with every single count against the organization, whether that specific individual participated in a specific crime or not. So RICO applies to both criminal and civil lawsuits. So not only can they be charged in the federal court, but they can be charged in civil courts by victims of their crimes. Under the RICO statute, racketeering activity includes murder, robbery, extortion, and many other several offenses, punishable by a minimum of 1 year in prison. Some of the other serious federal offenses include extortion, interstate theft, narcotics violations, money fraud, mail fraud, and terrorism. To be charged under RICO, a criminal enterprise has to have a pattern of at least 2 or more of the crimes listed previously, within a 10-year time frame, and they have to be indicted within the specific statute of limitations of the last predicate offense. So the statute of limitations when RICO was originally enacted was not set by Congress, but due to U.S. Code 18 under 3282, there's a catch-all for criminal violations, which says that it has to be done within 5 years. And then for civil RICO violations, under Rotella versus Wood, the court deemed that there's a 4-year statute of limitations, regardless of when the act occurred. Well, from the time the civilian discovers the incident, regardless of when the act actually occurred. So, previously stated, RICO was enacted in 1970 for 5 reasons. The first one is because of the drain on the U.S. economy. The illicit activities were draining billions of dollars annually from the United States economy. And then these illegally obtained funds were being used to fund organized crime groups. The funds were also being used to corrupt legitimate businesses. The criminal activities were weakening the U.S. economic system, as well as it was undermining the general welfare of the United States citizens. And the organized crime was growing at a rapid rate because of the ineffectiveness and the constraints that were in place against evidence gathering, as it was against individuals and not an entire organization. So the purpose of the RICO Act is to eradicate organized crime in the United States by giving the federal government more remedies to deal with the criminal enterprises. So since the original enactment of RICO, there's been several amendments. From 1978 to 2001, there were several predicate offenses added, including cigarette bootlegging. If there were 3 automobile thefts, bank fraud, terrorist activity, and tampering with witnesses. And then in 1988, a life sentence was able to be added if the charge itself already carried a life sentence. And then in 1995, civil RICO cases could not be based upon fraud in the purchase or sale of securities. Okay, so there are 4 specific violations under the RICO statute for dealing with the enterprise and the pattern of racketeering activity. So the first 2 are targeted toward the criminal enterprises as they're trying to infiltrate a legitimate business, and those are the acquiring an interest in an enterprise with racketeering income and acquiring an interest in an enterprise through racketeering activity. The third violation is targeted at racketeers who've already infiltrated a legitimate business and are using that business that they infiltrated to conduct more racketeering business. And that is C, conduct or participate in an enterprise. And then D is the conspiracy to violate any of the previous 3. So whether they were violated or not, just the conspiracy to violate them is a chargeable offense. So to plead a RICO claim under Section 1962C, the plaintiff must allege conduct of an enterprise through a pattern of racketeering activity. There are consistent issues that have been raised, and the biggest burden seems to be the burden of proof in proving the enterprise on the plaintiff. So if it's a legal entity such as a club, a corporation, a business office who is already on the record of for tax purposes because they were a legitimate business of some sort, then they don't have to prove that the enterprise. But if it's an association in fact formed off of an informal relationship, then they have to prove that the relationship consisted of meeting for a mutual purpose to engage in collective conduct. Also, the racketeering activity must have a direct effect on interstate commerce, or it has to be violent in nature to be a violation of RICO. So under Section 1963A, any person convicted under RICO can face imprisonment of up to 20 years per count, a fine, or both, unless due to that amendment the original charge carries a life sentence. Then under RICO that charge can also receive a life sentence. As well as treble damages and attorney's fees. For civil RICO cases, there's treble damages, I believe up to 3 times the amount that they were a victim of, punitive damage, and attorney's fees. So there are several famous cases that RICO have brought claims against. One of the first one is going to be a success story of RICO, and that is that of the Chicago outfit. So the original indictment included 14 individuals being charged with organized crime activities. 2 of those 14 were actual police officers who were assisting the Chicago outfit and finding out information and being pre-warned of things. So at the end, 6 of the 14 were indicted for murder on behalf of the outfit. The other charges along all 14 included extortion, running an illegal gambling business, tax fraud, obstructing a criminal investigation. So this case is one of the largest in regards to the number of murders being solved due to these convictions. The murders dated back to the 1970s. And the funny thing about this case is most of the charges were able to stick due to family relationships being strained. So Nicholas Calabrese pointed to his brother for involvement in many murders, and then Frank Calabrese Jr. actually provided information against his father, Frank Calabrese Sr., and his uncle, Nicholas Calabrese. Another famous case of RICO would be the Oakland Charter of the Hells Angels. This was not a successful case, though. So there were 2 different trials against the members of the Oakland Hells Angels. The first one included 18 defendants, and that case lasted 9 months. And the second one had 11 defendants and lasted for 4 months. And they both ended in mistrials due to a hung jury. The charges brought against the club under RICO were primarily for manufacturing and distribution of methamphetamine, along with other subsequent charges that were described as being part of their major plan to sell drugs. The largest hurdle in this case was the unwillingness of the jury to convict the club due to witnesses did not want to testify because they had already been granted immunity. And then on February 25th, 1981, Federal District Judge William Orrick declared the mistrial due to a hung jury, and then U.S. Attorney Robert Mueller declared that there would not be a retrial. The lack of the retrial came due to the fact that 2 trials had already cost the government an estimated $7 to $20 million. So when the Racketeer Influenced and Corrupt Organizations Act was written, it was done with very loose terms to cover the most ground and able to indict these organizations easier, but that has proven to not always be the case. The burden of proof that the relationships are, in fact, of an enterprise, as well as the related activity being committed on behalf of the enterprise, has shown to be no easy feat. RICO does, in fact, remain the greatest organized crime statute in history of the United States, as the government strives to take down these illicit organizations due to the incredible economic and criminal hardship that they place on the nation.